Hello everyone, my name is Vrinda Bhandarkar. I am a student of S.D.M Law College, and in this video we will be dealing with the concept of robbery and dacoity. Let's imagine a situation. In scenario 1, A takes away Z's goods without his consent. In scenario 2, A takes away Z's goods but on gunpoint. Would there be a difference in these two scenarios? If yes, what would be the difference? Do you think the punishment that is given to A in the first scenario and A in the second scenario should be different? And if yes, why? Are the offenses that are committed in both these scenarios different? Then in what sense is it different? So let's understand this within this video very briefly. The first concept that we will be dealing with in today's video would be that of robbery. Under IPC, from section 390 to section 402, the concept of robbery as well as dacoity have been comprehensively dealt with. Under section 390, it is stated specifically that every robbery either has theft or extortion. Therefore, we must understand here that robbery is nothing but an aggravated form of either theft or extortion based on the element of force present in it. Let's understand, when does theft or extortion become or transform into that of robbery. In case of theft, if there is theft plus violence or fear of violence, it transforms into robbery. Here violence is nothing but the causing or attempting to causing of either death, hurt or wrongful restraint. In case of extortion, if there is extortion plus the offender's presence plus the fear of immediate violence, and third, that the fact that the thing that is extorted has been delivered immediately to the offender. Now let us understand certain illustrations to understand this concept better. On a high road, A, that is the accused, meets Z, and he takes away all of Z's goods by holding Z down. If A had not held Z down and taken all his goods without his consent, it would amount to theft. But in this case, as he has held him down, it constitutes the offense of wrongful restraint and thus making theft a robbery in this case. Let's understand an illustration to the second case, that is as to when does extortion constitute robbery. A meets Z and takes away Z's child, holds Z's child near a cliff and states that if he does not give all his jewels to A, he will push the child down the cliff. Now here there is an instant fear of violence to a person in whom the complainant is interested and the offender is present at that scene. In such circumstance, extortion will constitute robbery. Let's now understand a case to this effect. Venu versus State of Karnataka. Here, the accused took away the jewels of the complainant by threatening him with a knife. Therefore, it was held to be an offense of robbery. Under section 392, robbery is punished with rigorous imprisonment of 10 years and can also be made liable, the person who commits it can also be made liable to pay fines. However, if robbery is committed in the time duration between sunset and sunrise, in that case the person can be made liable to undergo an imprisonment period of 14 years and can also be made liable to pay fines. 14 years of rigorous imprisonment as well as payment of fines. Under section 393 of IPC, attempt to commit robbery is punishable with rigorous imprisonment extending to 7 years and the person shall also be made liable to pay fines. Under section 391 of IPC, 5 or more persons are held liable for having committed dacoity when 5 or more persons conjointly either commit, attempt, abet or aid the commission of robbery. Here the whole number of offenders or the persons who are involved in the commission of attempting aiding or abetting of robbery must be 5 or more than 5. The reason why dacoity is considered to be a separate as well as a much graver offense than that of robbery is because of the sheer terror that is caused to the victim due to the presence and the terror caused by so many offenders, because it's 5 or more than 5 offenders. Also, there is need for the accused to have committed any overt act in order to hold him liable for having committed dacoity. In case if the number of offenders comes down after the offense has been reported during the court procedures, etc., if it comes to light that the number of persons who have committed dacoity is less than 5, then the rest of the accused cannot be held liable for dacoity. They will have to be held liable for robbery. Let's understand a case law. In Ramchand's case, a house was targeted by dacoits, and by seeing the dacoits approaching the said house, the persons or the inhabitants of that particular house were so scared and terrified that they fled that house. But in this case, the offenders were held liable for dacoity. Let's now understand what is the punishment that is prescribed for commission of dacoity. In case of dacoity, there is no difference made between commission of dacoity as well as attempting to commit dacoity. Therefore, the punishment for dacoity is either life imprisonment or imprisonment that is rigorous in nature extending to 10 years along with the liability to pay fines. Now let us understand certain aggravated forms of robbery as well as dacoity. Under section 394 of IPC, voluntarily causing hurt and committing robbery is punishable with rigorous imprisonment of 10 years and the person shall also incur liability to pay fines. Under section 396 of IPC, dacoity with murder is punishable with either death, life imprisonment or rigorous imprisonment extending to 10 years along with the liability to pay fines. Under section 397, robbery or dacoity caused with the attempt of causing either death or grievous hurt is punishable with imprisonment period of at least 7 years. Under section 398 of IPC, causing either robbery or dacoity while being armed with a deadly weapon is punishable with imprisonment period of at least 7 years. Under section 399, making preparation for committing dacoity is punishable with rigorous imprisonment extending to 10 years and the person shall also be made liable to pay fines. Under section 400 of IPC, the punishment for belonging to a gang of dacoits is held to be rigorous imprisonment of 10 years along with the liability to pay fines. Under section 401 of IPC, the punishment for belonging to a gang of thieves is rigorous imprisonment extending to a period of 7 years along with the liability to pay fines. Under section 402 of IPC, the punishment for assembling in order to commit dacoity is held to be rigorous imprisonment extending to 7 years along with the liability to pay fines. Thank you very much for watching this video. Happy learning.